we get when we read EU text. Lucia has given you a number of examples, and I mean, you can read that in the press. Lucia has given a number of names yesterday. Eurojargon, remember, it's also here on my slide. Eurojargon. There is also Eurospeak. Even some commissioner used Euromumbo Jumbo one day. So there is a kind of feeling that the EU uses language which sounds strange, right? And what I'm going to do, just a couple of examples. You've seen other examples in Lucia's presentation. Open method of coordination, comitology, European External Action Service, undertakings, the one that we just saw, common market organization. These are not transparent terms for most citizens. Is it switched on? Okay. Can you read it? Yes. Is this any better than? No, it's not. Okay. Closer. Okay, closer, yes. Good. So closer. Oh, okay. Right. Good. So some examples of that good weird feeling. What I'm going to argue today is that this is the result of a number of tendencies. Tendency to compromise, a tendency to multicultural decision-making in the EU, and also multilingual text drafting, but I won't have time to cover that. That's all about translation, etc. So I'm going to cover the first two aspects here, compromise and multicultural decision-making. I'll start with compromise. This is actually smaller print than I had expected, so I'm sorry for that. The EU is a ménage à 28, for those who understand French, not a ménage à 3, but 28 partners. I mean, we'll see in 70 days whether there is one less or not. The marriage contract that they have is a very complicated one, has been revised over and over and over again. What we notice as researchers is that every term has to be well thought of in that particular treaty, in that particular marriage contract. For instance, even prepositions are discussed, hotly debated in the European Council, because you have to realize that treaty on European Union, the preposition on there, has been hotly debated during the Maastricht negotiations, especially between Helmut Kohl and François Mitterrand, because everything that came before the Treaty on European Union was always called Treaty Establishing the European Economic Community, the European Steel and Coal Community, etc. Right? And then suddenly the practice changes. And why does it change? Because actually the European Union was not created by the Maastricht Treaty. It didn't have legal capacity after the Maastricht Treaty. It only acquired legal capacity with the Lisbon Treaty. So they couldn't really say that the treaty established the European Union at that time. So it was discussed what kind of preposition they would use in the European Council. So you must imagine all these heads of state or government discussing a preposition, right? I mean, there are records of that. One proposal was treaty towards European Union. Fortunately, it didn't make it. Huh? But you've got to realize that all these choices are well thought of, and they are sometimes hotly debated among political leaders. So linguistic choices are hardly ever random in the European Union. And we also struggle with that, I think. It's not a Ukrainian problem, I think. We all struggle with that. There are two main principles. I mean, there are more principles than that, but there are two main principles that you have to bear in mind. First of all, in legislation, in a treaty, never use terminology that suggests that the EU is a state or could be seen as a state. Okay? We tried that with the Constitution. Yeah? Constitution establishing, a treaty establishing a constitution for Europe. We used the word constitution, and it didn't work because the Constitution has been voted down in a number of member states. Don't use the word minister. Has been put forward a couple of times. Minister of Foreign Affairs, for instance, has been proposed. That was the term that was used actually in the Constitution for Federica Mogherini's function. But as the constitution was voted down, the word minister has been taken out of the Lisbon Treaty. You won't find it any longer. But it was a proposal. Foreign office. The EU has a foreign office, but it doesn't call it foreign office. It calls it, the one that we saw before, the European External Action Service, right? A very long word, complicated word, not very transparent, but it's a kind of foreign office. Don't say government, Don't say government, say commission. Don't say embassy, say delegation. Don't say tax, but call it own resource. And especially, don't use the F word. And the F word, in this case, is longer than 4 characters. What is it? Federation. Yes, okay. Federal, etc. So try to avoid, that's the European F word, federation. You've really got to avoid that word in the European context. The next thing has to do with what Woutia called a couple of minutes ago autonomy, autonomous. These legal terms have to be autonomous. You should not be able to confuse them with the national terms, right? So the EU, for instance, even in the treaty, will never call the civil service the civil service. In the treaty, it's called public service. And that's very confusing, of course, because public service has another meaning in English. Yeah. Don't call a company, but call it an undertaking. Don't call a lorry, but call it a large good vehicle. And don't speak of subsidies, but call these state aids, which makes you think spontaneously of Ethiopia and countries like that, of course. But state aid is the EU word for subsidy. And there is a very good reason to that. I mean, if you use the national words, these terms will be interpreted as if they were national law or legal terms, and you will get differences between the interpretations in the different member states. And that's not what it's supposed to be. There's supposed to be uniformity in application of EU law, right? And that's why the EU invents all kinds of new words or uses existing words with other meanings, etc. This, of course, has enormous effects. I've called that, in one of my previous presentations, terminological shockwaves through the whole system. Because, of course, if you try to avoid the word civil service, because civil services in different countries are very different, they include many different functions, etc. So the EU uses another word, public service, for that in order to give it an EU meaning. Of course, you end up with trouble because this treaty also refers to public services. And then you need a new name for the public service, right? Services of general economic interest. And it all becomes much more complicated and much longer, etc. That's what I call a terminological shockwave. Once you start playing with the system, playing with the term, I mean, terminology is all about the system, right? All these terms have relationships. When you start playing with one of these terms, the whole system collapses, and then you need new terms for all these existing concepts, right? So services of general economic interests is to be read as public service. And that's a problem, of course, because in some countries, public service is a constitutional term. In France, the term public service appears in the constitution. And then when you ask people to vote on European treaties, on European constitutions, etc., the first thing they're going to do is have a look in the treaty to find the word public service and what the EU has to tell us about public service, and they won't find the word. And that allows certain politicians to say that the European Union doesn't care about public service because it doesn't mention the word in the treaty. But the word is there. But no one recognizes it. Yeah? And then, of course, the EU thinks that it is a good idea to use acronyms. All these words become very, very long, and in order to shorten them, let's try acronyms. Right. So that was the first principle. Second principle is multicultural decision-making. And I'm going to refer to general cultural differences between member states. I'm just going to give you a couple of examples, right? Because I don't have the time to speak about that in detail. And then differences in legal culture. So at the table in European negotiations, you've got people coming from very different backgrounds, right? From very different cultures with very different concepts that that you could suppose to be the same, but that are not the same in these different cultures. And that poses a number of problems. So as I said, the Ukrainian example is not unique. It happens all the time in the European Union. So you make legislation, for instance, on fruit jams. You've got to be very careful to define what fruit is, because fruit is different in different cultures, right? The boundary between fruit and vegetables is different in different countries. And in some countries, in some member states, things are used in jams that in other member states would not be considered fruit, right? So, and that's why you get all these definition articles in EU legislation. Usually it's the first article that you get. By blah, blah, blah is meant, and then a definition in EU terms. So for instance, you have a Council Directive on fruit jams from 2001, and then it starts with, for the purposes of this directive, the following definitions shall apply. Fruit is blah, blah, blah. And then for the purposes of this directive, tomatoes. I mean, but this is the real boundary case, isn't it? Tomatoes, the eatable parts of rhubarb stalks, carrots. In some countries, carrots are used in jams. And if you want to cover them with EU legislation, you've got to include that in the definition, right? Sweet potatoes, cucumbers, pumpkins, blah, blah, blah. The problem is, if you don't do this, then some producers in some countries will not be covered by EU legislation and could be unlikely to be able to export their products to other member states. So you have to cover them, right? But fruit is different in every member state, and that's why you need these very complicated definition sections. Chocolate. Chocolate is a very sensitive issue, especially at home. I live with 3 women, 2 daughters and a wife, and I can tell you chocolate is a hot issue. Now, chocolate has a different meaning in different cultures. There is a continental chocolate, chocolate produced in Belgium, France, etc. But there is also another kind of chocolate. And there were chocolate wars in the European Union. From 1973 until 2003, actually, chocolate wars were actually the wars that were started by the fact that the UK joined the European Union in 1973, but the member states of well, not the EU, but the EEC, the other member states did not accept chocolate that was produced in the UK on their markets. The EU is about free movement of goods, but that was one exception. Because chocolate in the UK is produced with less cocoa butter than in other member states. So the other member states said, okay, this is all very well, but your chocolate is much cheaper than ours, so you're going to create unfair competition conditions, so we're not going to allow that particular kind of chocolate that you produce on our markets. It took them 30 years to make peace in the chocolate wars, because for 30 years, chocolate from the UK was not allowed in Belgium, France, etc., and Spain. There was one proposal, and this is terminology, yeah? This is active terminology making. There was one proposal from Belgium, France, to say, okay, let's not call the UK. If you want to export your chocolate to the continent, that's okay, but we won't call it chocolate. We'll call it vegetate. Because it's produced with vegetal oil and not with cocoa butter. Yeah? A directive in 2000 settled the problem. Well, there was also a problem with too much milk in chocolate. So a directive in 2000 settled the problem. So the problem is no longer a terminological problem. The chocolate produced in the UK is sold on the continent as chocolate, but for that particular kind of chocolate that is made with more milk than you would expect on the continent, there is a special name. Because, for instance, this chocolate, Cadbury chocolate, can only be sold under the term family milk chocolate in the European Union on the continent, right? So that makes a distinction between the usual milk chocolate that we know on the continent and the milk chocolate that is produced in the UK. Still, after the 2000 directive, Spain and Italy refused to sell UK chocolate on their markets and obliged UK producers to use the name chocolate substitute on the chocolate itself, so in the shops. That decision was challenged before the European Court of Justice, and the European Court of Justice there sided with the UK, or with the Cadbury company actually, who was producing that kind of chocolate. I mean, this is only chocolate, right? But you can see what kind of trouble people have to go through to agree on what chocolate exactly is. Yeah? So, very different cultural backgrounds, very different legal cultural backgrounds as well, right? You have countries with common law, with civil law in the European Union, you've got non-interventionist governments, interventionist governments, etc. So in some cases it's very difficult, and conceptual work is extremely important in the European Union, okay? Because as Wucia has explained, once you use a particular term, that term will automatically trickle down to the national context, and it has to fit the national context as well, of course. A couple of examples where that creates problems. A contract. Can you think of anything more banal than a contract? But a contract is something different in a civil law system than in a common law system, right? In a common law system, a contract is typically a text that you sign in which value is exchanged between parties, right? On the continent, a contract can be unilateral, okay? And that creates problems because a contract, on the continent we have marriage contracts. There is no exchange in value in a marriage contract, or you have to go back to the Middle Ages, I think. And so the word contract is not used in that context in the UK. And that makes it very hard, for instance, for people coming from the continent, settling in the UK, to annul their marriage contract, to have a divorce, etc., because UK judges don't recognize the marriage contract, because for them it's not a contract, right? So it's a kind of limitation to free movement of people. Well, it's only, I think now, 6 years ago, there was one case before the British court where the judge accepted the marriage contract as a binding document between the two spouses. So that's only 6 or 7 years, I think. Goods. Goods are different in civil law than in common law. The word goods in English refers to stuff that you can move. Chairs, computers, etc. On the continent, most of the equivalents of goods can be used in both meanings. Stuff that you can move and also stuff that you can't move, like land, property, houses, etc. For instance, if you take the French equivalent, bien, you can have bien mobilier, the things that you can move, and bien immobilier, the things that you can't move. And bien immobilier typically are houses, etc. But the English term only refers to the movable stuff, right? And if you make legislation, you have to carefully think of that, because if you use the word goods and the equivalent in the other languages, you will have two different legislations if you don't foresee that problem. So that's why, for instance, again, you get a definition section in most of the legislation that is about goods. For instance, contracts negotiated away from business. It's an old one from 1985. This directive shall not apply to contracts for the construction, sale, and rental of immovable property, etc. So you have to add something in order for the were the legislation to apply to different cultural, legal cultural systems. Now the trouble is that sometimes that provision is forgotten. Yeah, so usually you get a kind of restriction saying, it doesn't do this. And in some cases, that provision is not there. And then what's the result? Well, the result is that you get problems. Because this directive on unfair terms from 1993, it's an important one, deals with a number of conditions that sellers of goods have to comply with in order to be able to sell their goods. For instance, a 2 years guarantee, stuff like that. And also the fact that clients have the right to visually inspect the thing that they are buying. That's one of the items in that directive. Now in the UK, there has been an immigration wave a long time ago, in the early 2000s, in the 1990s, where immigrants, there wasn't enough housing for these immigrants, and they were housed temporarily in bed and breakfasts, hotels, etc. Cost a lot of money, of course. So the Brits published a Housing Act in which one of the provisions was that municipal councils would have to provide lodging for immigrants, etc., that social houses could be used for that, and that all kinds of projects would be started up to do that. So, in fact, the idea was to move these people out of the bed and breakfasts and hotels and to move them into kind of social housing projects, right? Now, the trouble was that one immigrant family was proposed an apartment on the first floor of a particular building, and they said, we don't want that, because we have a handicapped person in our family, and he can't go up the stairs, and there is no elevator. So they refused. They refused, and then they were, of course, declined the right to housing afterwards, because they had refused. They went to court, and they went to court on the basis of the directive on unfair terms, saying we didn't have the right to visually inspect our apartment. It was only when we were there, when we had to move in, that we saw that it was on the first floor, etc. So we want this decision to be annulled, and we want another type of housing to be proposed. And then, of course, the question is, does the unfair terms in sale of rental of goods, does that apply to this situation, right? If the directive of unfair terms had the special provision saying it doesn't apply to rental, etc., then there would be no reason for this case, actually. But the family said, in Council Directive, which was transposed into British legislation, nothing is saying that it would not apply to housing, to rental of houses, etc. Okay? There is no special provision. So we have a case here. The UK government argued, yes, but this is just an omission. It should be there. We should read the directive as if it were there. Because in English, in any way, the word goods is only used in that meaning. It's only used in the meaning of movable stuff and nothing else. Okay? The court sided with the family, which means that from 2004 on, actually, the word goods in English has changed meaning, because it also covers land, property, etc., as a result of this case. And you know how strong cases are in, or what influence a case can have in British legislation. Okay, trying to go to, okay, some final comments to round off. So the good weird feeling that we have when you see EU terminology is actually an inevitable result of how the EU works. And as I said, the Ukrainian case is nothing unique. It happens in all these languages, and even English changes as a result of EU terminology, and cases are brought before courts on the meaning of EU terms. But the problem, of course, is that it is also an aspect of the gap between the EU and citizens. because citizens don't recognize the terminology that they are used to. And that's an enormous problem. It's also one of the, I would say, linguistic aspects of what is sometimes called the gap between the EU and the citizen, or even the democratic deficit, because citizens don't understand EU law because of the properties of EU law. And then they vote against the EU in referenda and stuff like that. And it's a problem, I believe. It's a problem that we have to reflect on as academics. And this is a picture of that gap, right? Okay, that was it. Thank you very much.